Good afternoon, everyone. I'm Laura Vogel, your Narpm Orlando Central Florida Chapter President. Thank you all for joining us for this important update from Harry Heist. And thank you, Harry, for the time you dedicate to our industry to keep us out of trouble and help us make better property managers. I wanted to take a minute to talk about Narpm. Right now, if you do join from this seminar or webinar that we're having today, you do get a $50 discount. So you can find out more information and join on narpm.org. So some questions you might have is, what is Narpm? Maybe people are on here who are not members. So Narpm is an association of real estate professionals who know firsthand the unique problems and challenges of managing single-family and small residential properties. And why do members value Narpm? Well, because you have access to things like this that we're holding today. So it's the success, the education, the classes, the designations, the information sharing, the networking, the ideas, the friendships, the return on relationships, the member support, the results, and do it for your own personal growth. If you're on the webinar again and you're not a member, please consider becoming a member today. Go to narpm.org and save $50 today. I want to take another moment to update you on some upcoming events. May 18th and 19th, National has the Legislative and Educational Virtual Conference. Typically, this is not virtual, it's an in-person conference. This year, it's free for all members. So sign up on narpm.org for that. May 21st, our chapter, Orlando, is having a new member orientation. That's from 3 to 4. Anyone interested in that can contact me, Alex, or Christy. May 27th and 28th, we have our designation class, Profitability and Owner Relations. That's a virtual class we're holding, 9 to 12 each day. June 11th from 10 to 11:30 is our chapter meeting. Take 10 KPIs to help you know and grow your business, and that's with Brian Jenkins, so that'll be a good one. August 13th is our biggest event with Harry Heist, 6 CE credits on all legal things that you need to know. We're holding that this year at the Ritz-Carlton, hopefully in person. October 20th through 23rd, the national conference is right here in Florida at Amelia Island, Omni Amelia Island Plantation Resort. It'll be a fun time for all. At this time, I'll turn it over to Alex Zoidoff. He's our president-elect. Thank you, Alex.
Hello, everyone. Thank you for joining us today for our COVID-19 update with attorney Harry Heist of Heist, Weiss & Wolf. My name is Alex Zoidoff, and I'm the 2020 Narpm Orlando Central Florida President-elect. It brings me great pleasure to introduce today's speaker, Harry Heist. Attorney Heist has been the property manager's go-to attorney since 1989. He represents over 11,000 property managers in Florida and has filed close to 200,000 evictions. He has written and co-written most of the pro-landlord changes to the Landlord-Tenant Act in the past 30 years. He works for large multifamily, single-family home managers of all sizes and some smaller self-managers. Harry is a huge Narpm supporter and a member since 1992. He helped form most of the Florida Narpm chapters and is a member of every Florida Narpm chapter and Narpm national affiliate. His firm has a staff of 22 secretaries and 3 lawyers. His website, evict.com, is the largest source of Florida-specific legal information for the property manager, and evicttv.com has over 200 free training videos. Heist, Weiss & Wolf is the largest property management law firm in Florida. Harry is committed to keeping Florida a landlord-friendly state. Please join me in welcoming attorney Harry Heist.
Thanks, Alex. All right, well, I'm going to dive right into it. First of all, I want to thank Alex and Laura for everything that they did to get the class going today, and also for all the work that they do all throughout the year. Narpm is a group of volunteers. No one is getting paid, and it's amazing the amount of work that goes into a chapter and what these volunteers are doing, and they're doing it for their competitors in many cases. So it's just a beautiful thing that we have Narpm for the property managers. If you're not a member of Narpm, I really urge you to join. Almost every successful property manager in Florida is a member of Narpm. So if that doesn't tell you something, I don't know what does. If you're successful, most likely you're a Narpm member. There's a lot of people that aren't members. As Alex mentioned, I work for and I couldn't believe that I worked for this many people. It's funny with all this COVID stuff, we went and we started looking at numbers and looking at money things and all kinds of stuff. And I asked one of my secretaries and I said, could you figure out how many people that we actually work for, how many people who consider themselves property managers that we work for? And I looked at the list and it's over 11,000 in Florida. And then I look and see, well, how many members do we have of Narpm in Florida? And I'm not exactly sure of the number, but I think we're only around 800-900. I don't know if we've hit 1,000 yet. I'm really not sure. Maybe Alex or Laura knows. But what it goes to show is that the majority of property managers in Florida are not connected to the law. They're not connected to the successful people. They're not connected to Narpm. And in most cases, they're not even connected to the Association of Realtors either. And that's really bad. People need to be connected. If you're going to manage property for others, if you're going to take the responsibility of managing an asset that could be worth hundreds of thousands of dollars, you really need to do it the best way you can. And if you want to learn how to do it right, we highly recommend that you become a Narpm member. All day long, I've been getting emails. Most people communicate by email. They get a lot of questions by phone, but the vast majority are emails. I would say about 1 every 5 minutes. And I would say that at least 75% of the emails that I get are asking about things like evictions, about tenants who don't want to allow showings, you name it, everything that you guys are dealing with, I get those questions. And in almost every single case, I have to ask them a question before I begin. And I send them an email. I say, is the property covered or not covered? And you want to know something? Almost every single time I get the answer back. What do you mean? They say, you mean with insurance? So what this is showing me is that the absolute vast majority of property managers in Florida do not even know what we are dealing with right now. Now, some of you are more in tune with this. You've been keeping up with the Narpm emails. You see the stuff coming from far. Some of you are even apartment association members, and you're more up to date on this stuff. But the majority of people have no clue. So if you do have a clue, that's great. Today, hopefully, we're going to get even in deeper. But it's scary. It really scares me when I see how we have so many people out there who are not connected, and they are doing something that requires work and has a lot of liability involved in it. So I really urge you, join Narpm. Also, if your Association of Realtors has a property management council, for instance, Aura has a great property management council, join that as well. Almost every Narpm member is also a member of the Association of Realtors. So we're all working together in a lot of things. In fact, I want to tell you right now what's happening right now. Right now, today, is the second meeting of the eviction task force. This is done, it's not in person, but it's the eviction task force with the governor. It has members from the DBPR, from the Florida Association of Realtors, from Narpm, from the Florida Apartment Association, and from the legal aid organizations. And this is a very important thing that's going on right now because the governor is thinking about extending the moratorium that we're going to talk about today. And without those other groups at the table, if only legal aid was at the table, could you only imagine where we would be today? So we need to come together as a group. We need to work together. A lot of single-family home managers have operated in their own little vacuum, unlike the Apartment Association, unlike the Association of Realtors. Those are associations where people have really worked hard and they understand the importance of being in a group and the legislative power that we have as a group. Narpm doesn't have a lot of power right now, but we have people. And if you don't have money, but you have people, at least we're part of the way there. So we're all working together with this, and it's always good to have people from all different associations be involved in Narpm. to try to get what we need. If you look around the country and see what's going on in other parts of the country, in California is the absolute worst, the crazy laws, the bizarre stuff that's happening, New York is bizarre, all of this stuff could happen in Florida, every single bit of it. Don't think for a minute that it can't, because stuff is already happening. It's happening quietly. So it's sneaking in the counties, it's sneaking in the cities, and then and there's bills introduced every single year that are anti-landlord bills. And without the Florida Apartment Association, without the Florida Association of Realtors, without Narpm, I'm telling you, these bills would pass. I know this for a fact. You don't even see these bills because we get them killed before they even make it on the radar. It's bad stuff, and it's going to get worse. And look at what we're dealing with right now. All right, so what we're going to do today is dive into what we're dealing with right now, how the COVID-19, the laws, how they're affecting you guys right now in your day-to-day operations. Start out with some good news. We got a little good news going on right now. We have a pretty low delinquency rate with single-family home management. Multifamily is a lot higher. It's about 85%. That is pretty high when you think about a 300-unit apartment community where it used to be 95%. Now we're down to 85%. Single-family home managers are doing very well right now if they know what they're doing. You'll notice, and I looked at the numbers, and I looked and I saw how many evictions do I do for Narpm members, and I work for almost every Narpm member. I looked at it and I'm like, oh my God. I would be broke if I only did evictions for Narpm members because they hardly have any. Why is that? Because they know what they're doing. They know what they're doing. They screen better. So a lot of you are reaping the benefits of the screening that you've done in the proper way of doing things. You're reaping those benefits right now. So you should be proud of yourself that you're in that boat. A lot of people are doing great right now. We got some people collected 100% rent right now. So that's pretty darn amazing. But we're not over yet. It could get bad. Another good news thing is leasing. Leasing is at a very high level. You know, we prepare leases for hundreds and hundreds of property managers. We prepare tons and tons of leases, tens of thousands of them a year. And our leasing numbers are great. And that's a great barometer of what's going on in the state. People are moving, people are leasing. So that's doing well too. So those two things, the rent, the leasing, the low delinquency rate, those are really good things as far as I'm concerned. And that's great. Before I go any further, I want you all to just think about your property management agreement, which is the most important document. Sometimes I'll ask people, what's your most important document? And they'll say, oh, we need a good lease. You can have the best lease in the world, and it's not going to save you. What you really need is a good property management agreement. And there's a particular clause that I like in the property management agreement. And that clause has to do with charging mandatory management fees. Now, because of antitrust laws and things like that, I can only tell you that a lot of my clients do that. A lot of people do that in Florida, but a lot of people don't. They have a mandatory minimum management fee. And the property managers who started doing this 10, 15, 20 years ago are reaping the benefits of that mandatory minimum management fee. This is where you're going to get paid a management fee, whether there's a tenant in there or not, whether you're collecting rent or not. And in my opinion, and I felt this way for years, you deserve it. The liability you have, the work involved in it. This is not sales. With sales, you get a listing, you get a deal, and you get a big check. Not that way with property management. With property management, you sign that property management agreement, and the headaches and problems and the liability and the responsibilities begin right there. So if you don't have that in your property management agreement, I want you to think about it and think about whether I'm right about that or whether I'm wrong about that. And I think you're going to come to the realization that you deserve it, and it's a good idea to look into. And I'll give you the wording if you want. We have a free property management agreement we give out to everybody, so you can play with that and make your own out of it. All right, so enough of that. Let's talk about what's going on. There's a lot of confusion right now about what's going on with the laws. And if you're not confused, you might think that you know what's going on, but you really don't. So we're going to go into each one of the three things that are affecting you right now. Forget about the stuff that you're reading on Facebook. Facebook is one of the biggest sources of misinformation. Yeah, it's got a lot of good information on there, but it's a lot of misinformation, especially when it comes to legal things. And the reason why is that Facebook, you got people from everywhere. You ever see somebody ask a question and then somebody proclaims the answer like it's the gospel, and they're from another state? This is Florida. We have Florida laws to worry about. Yeah, we got federal laws to worry about, but we got Florida right now, and that's what we need to know. That's what you need to know. So don't get yourself confused. Don't get confused by a lot of the stuff you read. Also, don't get yourself worked up. You know, I'm one of these guys, gets on Facebook. I can get worked up real fast. I love to get into a fight. I love to, you know, I love to be challenged. I love it. Okay. I'm just one of those weirdos. And I see what people are writing on there. And a lot of them are just plain dead wrong. And this information circulating. There's also a lot of speculation going on. You're going to see speculation about what's going to happen in the next phase of the stimulus. Are people going to not have to pay rent for a year? Don't get yourself worked up about that. It's bad enough. Don't let speculation get you all worked up. Let's deal with what we got right now. Let's deal with the solid stuff that we know right now before we're going to worry about anything else. All right, first thing, I hope every one of you has done something to talk to your owner or email your owner or do something with your owner to let them know what's happening. Not freak them out, not scare them, but to let them know that stuff's happening, because, you know, they're reading the same stuff and they're watching stuff on TV as well. And I know if I'm a landlord here in Florida, but if I were a landlord and I lived out of state, I would be very, very concerned. You know how your owners get really concerned when there's a hurricane? They panic, right? Everybody's calling you up and emailing you. They want to know, how's my house? How's my house? How's my house? And you have to calm them down, right? Well, this is the same type of thing. This is the biggest hurricane we've ever dealt with. This is worse than anything we've ever dealt with. And your owners are scared. Your owners are concerned. Your owners are confused. And there is a movement in this business to do every single thing electronically, to make everybody turn into a number, to scale. And people say, oh, you can't get big, you can't make money, you can't scale if you're going to communicate with people. And I disagree with a lot of that. You can do both. It's harder, but you could do both. And right now, you need to step into the shoes of your owners and talk to your owners or email your owners with maybe a semi-personal email, something, so that their fears are going to be reduced, because people are afraid. And when they see that you care and that you understand the law and that you're a professional, they're going to stick with you. You have a higher chance of them sticking with you. When somebody becomes a number, yeah, you'll make more money, but will they stick with you when somebody else comes along with some shiny object or some really cool looking thing? So I'm a big proponent of, at least in a situation like this, let's take the time and have a little bit more contact with the people that we manage for. To us, you know, just like with me, I have done so many evictions that they don't faze me. And I totally forget that the property manager is stressed out, the owner is stressed out. Some of them get sick. They literally get sick when they have evictions. It's just so terrible. I'm dealing with a situation right now with a squatting situation. I'm dealing with one where a person just moved in. A property manager made the mistake of moving somebody into a house without the owner's permission. And I mean, this, you could tell, this is destroying this person's life right now. And I sometimes have to realize, you know, this is really important to these people. They're not just a number. And I have to step back and understand what they're going through. I'll understand what your owners are going through right now, because it's not pretty. All right. Where are you going to get your information from? Well, here you are, Narpm. You've got the emails that are coming to you from Narpm. You've got the stuff that's coming to you from FAR, the stuff from Aura, the stuff from the different associations of realtors. You got all the stuff that's on our website. Get this information, because it's serious stuff. The people who are putting this information out are not doing it because they want to. I didn't spend all this time putting all this information out because I love doing it. I did it because I had to, because the potential is high for you guys doing something wrong and end up having a serious problem and possibly get sued, lose an eviction, class action lawsuits. Anything can happen. Because right now we've got 3 big things going on, and now we've got people watching us. We all know about legal aid. There's a legal aid office in almost every decent sized city. Legal aid, they help people that don't have much money. They help elderly people. They help people who are disabled. But they go beyond that. They are true advocates of tenants, and they advocate nationwide. They have large lobby groups. So when I say lobby groups, they don't have actual lobbyists per se, like we would have a lobbyist or FAR would have a lobbyist, or the apartment association, but they have a lot of time on their hands. And what they do is they spend a lot of time going and sitting down with the different legislators, whether it be state, local, federal, and they get the ear of these legislators, and they are trying to convince these legislators that things have to be done to stop evictions, to delay evictions, to help their tenants, help their clients, help their people get the help that they need. But a lot of those things do not align with you. They don't align with what you're trying to do. So just be very careful, because they're out there right now. And what they're going to do, and they've already started, they are going to represent tenants like you've never seen before. Most legal aid organizations, they used to be bad. Years ago, they used to be worse. But what they do now is they generally, in the past 15 years, they won't represent people if they're absolute deadbeats. They won't do it. They really want to see somebody who needs help, where the landlord maybe is making a mistake or something, or the property manager made a mistake, and then they will take on a case like, they'll take on an eviction, for instance, and they'll fight. They don't generally go and try to help drug dealers, deadbeats. They don't do that. But right now we have a little different situation. We've got so many people who are in trouble, so many people who need help. And what they're doing is they send these cases out to private attorneys. And there's tons of private attorneys out there that are taking these cases. And what they're doing is they're going to be representing tenants to drag the eviction out, or try to find a defect, or try to get your eviction bounced out of court. And if they win, what do they get? Does anybody know what they get? They get an award of attorney's fees. And a lot of you have not experienced that, but some of you have. Some of you know there's a guy in Orlando that has gone after many of you, and many of you have paid out between $2,000, $10,000, $15,000 to this attorney. There's more than one of them too, attorneys that do this in the greater Orlando area. They're pretty vicious, and they know the law, and they're going to be looking at everything that you do. So what do? Dot our I's, cross our T's, do it right. Then you don't have to worry. If you do it right, you don't have to worry. If you're going to be sloppy about it, you better worry, and it could cost you a lot of money. And that's why we're picky. That's why we tell you, do that 3-day notice over again. Don't put late charges on that 3-day notice. Don't do this. Don't do that. Sometimes you get angry. But why do we tell you this? Because we don't want you paying out 10 grand. Because if you have to pay out 10 grand, you're going to be really angry at me. The owner's going to be angry at you. You're going to be angry. Everybody's going to be really angry. All right, let's dive into it. What do we got going? The Supreme Court ruling right now. That's easy. Let's get this out of the way. The Supreme Court has a ruling that says that no writs of possession, the end of the eviction, the absolute bitter end, no writs of possession where the sheriff kicks the person out of the house, no writs of possession will be executed until after May 29th. Okay, got it? Mark that down on your calendar. Nothing's going to happen until after May 29th. The sheriff will not go out there and meet you at the property and kick out a tenant for any reason whatsoever, May 29th. All right. Next thing we got going. We got the CARES Act. Okay, the CARES Act. Not going to talk about that yet. We're going to hold on that one. The next thing we have is the executive order by the governor. That was signed on April 2nd. Most of you, I hope, a lot of you don't, because I know it when I see these emails coming in. And you know, they don't come in from the Narpm members. They come in from the people who are on the periphery. They're the ones that are not connected. I see it all day long. We have a 45-day hold on non-payment of rent evictions. Okay, very simple. No non-payment of rent evictions until after May 17th. Period. End of story. I don't care what kind of property it is. That's the governor's executive order. There's nothing we can do about that. Now, what's being done about it? Well, the eviction task force. The eviction task force is working with the governor, and we're going to find out very shortly, maybe even today, maybe tomorrow. We're going to see if the governor's going to extend that May 17th deadline. There's a really good chance it will be extended. How far will it be extended? We don't know. Obviously, we've got our groups up there who are trying to extend it, and we have the groups up there who are trying to not have it extended too far, if extended at all. But there's a 45-day hold on everything. So there's just people call me up, they're like, I want to file an eviction. I'm like, first of all, I know you haven't read a thing, but you can't. And they're like, well, why can't we? Well, there's a 45-day hold for non-payment of rent evictions. All right, so the laws and these orders and all these things that came out, they were very poorly written. They're a little bit vague. Some people like to argue about what they mean, but the consensus, what I'm going to talk about today is the consensus. What most of us lawyers, almost every one of them, and there's only a few really big landlord-tenant lawyers in Florida, and even in the country, there's not a lot of landlord-tenant lawyers that this is all they do. But this is the consensus that I'm giving you today. We all agree on what I'm going to talk about today. So we've got these three things going: the CARES Act, the executive order, the Supreme Court thing. Okay? The smallest mistake you make right now could end up triggering a lawsuit against you, could trigger an eviction being thrown out of court, could trigger a protracted eviction, and worse yet, could trigger a having to pay attorney's fees to the tenant's attorney. That's one of the worst things about Florida law. Florida law is awesome. It's absolutely great for landlords. That's why more and more people are coming to Florida, and it's not going to stop. They're coming, man. They are coming to Florida, and they are buying rental property because Florida still is one of the best places in the country, if not the best, to have rental property. And it's because of FAR. It's because of FAA. It's because of Narpm that we have this stuff, and we want to keep it this way. So the executive order, the governor's executive order, applies to every single property in Florida, every single residential property in Florida. No non-payment of rent evictions until after May 17th. No 3-day notices until after May 17th. Now, some of you are like, oh, wait a minute. What do you mean? I gave a 3-day notice. I gave a 3-day notice to my tenant. Well, don't do it again. Okay? Chances are you're not going to get busted, but don't do it again. No 3-day notices while this executive order is in place. And don't forget, it could change and it might change. So what you're hearing today may be different tomorrow. Now, people ask me, they're like, well, if I can't serve a 3-day notice for my tenant, what can I serve them? You could serve them what's called a reminder letter. It's not, it doesn't have any consequences. It doesn't threaten eviction. So you can't threaten something that you can't do. That's why people are like, well, why can't I give a 3-day notice? Well, what does a 3-day notice say? It says pay the rent or we're going to evict you, right? Well, you can't threaten something that's illegal. It's totally illegal to threaten something that's illegal. Like if a debt collector called you up and said they were going to sue you about a debt that you incurred 10 years ago, that would be illegal, right? Why would it be illegal? Because of statute of limitations. The statute of limitations would not allow you to, the statute of limitations ran. Now they still could ruin your credit, but they can't sue you. So you can't threaten somebody with something that you can't do. But on the other hand, if you don't communicate with your tenant, maybe they're not going to bother communicating with you. So maybe you're not going to get anything from them. So it's important. Communication is really crucial. So we have a form. It's called a rent reminder letter. And this is all the attorneys agree on this. It just tells them what they owe. No late charges, no penalties, no fees, no nothing, rent. You're allowed to serve that now. Has no deadlines, no nothing. Take a look at it. Go to evict.com, and after the class, I'm going to be sending Alex and Laura a Dropbox file with a ton of good stuff in it, all in one place. So you don't have to fish around for it on the website. It's going to be all in one place. And if you want a Google Drive one, we can turn it into a Google Drive one as well. So you are going to, right now, if you have somebody in a non-payment status, you're going to serve them a reminder letter. Put those 3-day notices aside. You're going to use this reminder letter. It tells them what they owe. Okay, great. So now we know that we could use this reminder letter, and you could use this for everybody. You could use it for CARES. We're going to talk about covered CARES properties, and you could use it for regular properties. It doesn't matter. Now, some of you are like, okay, I got it, Harry. May 17th is the date. Hopefully, probably not, but May 17th is the date. So after May 17th, which is really very soon, right? After May 17th, we should be in good shape. We'll be back to normal again. Well, that's not necessarily going to be the case, because it's going to then depend upon what type of property you have. So if you have a CARES covered property, it's going to be totally different. Once the governor's moratorium is lifted, whether it be May 17th, May 30th, May 31st, June, who knows? Once it's lifted, if you have a normal property not covered under CARES, you're going to be able to do everything like you did before. 3-day eviction. And by the way, most of the courts are open, not all of them, but most of them are open right now. So things are going to probably get back to normal pretty fast for your normal properties, for your non-CARES covered property. Now, what about non-compliances? Suppose you got a situation right now where tenants are in non-compliance. Maybe you got a call from the condo Nazis, called you up and they said, your tenant has unauthorized occupants. We're dealing with a lot of that. Your tenant hasn't cut the lawn. The lawn's 3 feet tall. Your tenant's doing this, your tenant's doing that, or your tenant you allowed your tenant to move in without having approval. You name it, right? Your tenants do things. In good times and bad times, tenants do bad things. what can you do? Are you stuck? No. The executive order by the governor and the CARES Act, it applies to non-payment of rent. It doesn't apply to non-compliances. If your tenants are doing something wrong, you still are able to proceed. Your hands aren't completely tied, they're just partially tied. So you got one hand behind your back. You still will be able to proceed on non-renewals and also for non-compliances. So, and that's something that's very important, because think about it. A condo calls you up, tells you that your tenant's doing something wrong. You can't ignore that. If you ignore it, you'll pay a big price for that. You know it, right? If you've ever dealt with condos. So you are allowed to give notices. You are allowed to proceed almost as normal, and you are allowed to file evictions even under the moratorium. Remember, the moratorium applies to non-payment of rent. Doesn't talk about unauthorized occupants, doesn't talk about unauthorized pets, doesn't talk about non-compliances. What about non-renewals? Can you non-renew somebody right now? Suppose somebody's on month to month. You want to non-renew them, can you? The answer is yes. Suppose a lease is up. Suppose a lease is getting to the end, and your owner says, "No, I don't want to renew that lease. I want to sell that house. I don't want to renew the lease." Can you non-renew the lease? The answer is yes. If they don't leave, can you file an eviction? If they don't comply with the 7-day notice, can you file an eviction? The answer is yes. So remember, this is about non-payment of rent. Non-payment of rent. Focus on that, because a lot of people thought, oh, I can't do anything. But here is a little tricky thing. Some of you, right when you found out about the governor's executive order that said no evictions, right? No evictions for non-payment of rent. A lot of you did find out from reading my stuff or watching the videos. You found out that you can proceed on non-renewals and you can proceed on non-compliances. But you know what some of you did? I knew you'd do it too. You guys called me up or emailed me and said, "Harry, I got to get this person out. They have an unauthorized occupant. They have an unauthorized pet. They're doing this, they're doing that, or I want to non-renew this person." So then I figured, let me ask a question here. I said, "Are they current with their rent?" And what do you think the answer was? No, they haven't paid March or April's rent. Okay, now let's get down to it. What were you really trying to evict them for? What were you really trying to evict? You were trying to evict them because they haven't paid the rent. So you were trying to get around it, like the loophole, so to speak, which is not really a loophole, but it looks like one. You were trying to get around the law that says no non-payment of rent evictions by doing a 7-day notice or a notice of non-renewal. You can't do that. You're going to need a reason now. If you're going to non-renew somebody, you better have a good reason. Now, see, in the past, you don't need a reason, but you're going to need a reason to non-renew, because if they say if the tenant says the reason is because they haven't paid the rent, you're going to have to come back and say, no, the reason was not because they didn't pay the rent. The reason was because my owner wants to sell the property, or my owner wants to move in, or they're doing X, Y, and Z. So don't think that all of a sudden now, and a lot of you did and still do, you're like, oh, I'm going to give everybody 7-day notices. I'm going to file an eviction for something else. You know, when you're grabbing at straws, right? You ever have that where you're sitting there, you're thinking, what can I evict them for? You know, okay, if I can't do it for this, what can I know. Look, I know. I want to file the eviction too. But I don't want you to lose. So we have to be very cautious about that. Non-renewing or non-compliances, we want to make sure that the real reason, the underlying reason, is something serious, not some baloney. Don't try to evict somebody for an unauthorized pet when you knew they had that unauthorized pet for the last 6 months. The judge sees right through that, right straight through it. I see through it, and any property manager can also see right through it. Everyone knows, okay? So what do you need to do right now? Relax. Relax right now until May 17th, or if it gets extended, it's going to be later than that. Also, I want you to understand this. The whole protection, this whole protection for people who are not paying their rent, it doesn't just protect people because of the COVID-19 situation. They don't have to be affected by COVID-19 in order to have the protections. And some of you thought they did. You said, oh, my tenant's not affected at all by COVID-19. He's still working right now, but he's just not paying the rent. Doesn't matter. It doesn't matter. No matter what the law says, when you read it, it makes it look like they have to prove that they've been affected by COVID-19. No, they don't have to prove a darn thing. They are covered. The laws apply to them whether or not their problem whether their non-payment rent problem is due to the fact that they lost a job, or they're just bums and they're sitting there not paying the rent because they're going to take advantage of the situation. And anytime there's a situation, people are going to take advantage of it. All right. Now, after May 17th, or the extension date, if it happens, you're going to have to worry about the CARES Act. Now, listen super carefully on this. And if you don't catch it the first time around with this class, don't worry about it. I got so much in writing on this. I've got videos on this. If you don't catch it, you'll catch it if you take a little time. This stuff takes a little time to absorb because it's so messed up. Listen real carefully. The CARES Act does not just apply to HUD, Section 8, low income housing tax credit. It goes way beyond that. And some people thought, they're like, oh yeah, I heard about that CARES Act. It applies to government properties. It applies to HUD, Section 8, low income housing. Goes way beyond that. And this is what's really scary. It applies to properties where the financing of the property, it does apply to HUD, Section 8 and all that other stuff, but it also applies to properties where the financing is connected to the federal government in some sort of way. So the super obvious ones are, if you have a Section 8 voucher, that's super obvious. If you have, if you're getting any kind of government assistance on a property, that's obvious. You all know that. That's a covered property. Covered's the bad word, by the way. Covered is bad. Covered sounds like a good word, because like, I got insurance coverage. Oh, that sounds good. No, covered is bad when we're talking about this stuff. If the loan to the property is connected to Fannie Mae, Freddie Mac, or purchased or securitized by the Federal Home Loan Mortgage Corporation, if there's any connection to any of that stuff, that means the loan is covered. So what you're going to do is you have to now understand what covered means, and then you're going to have to find out the property that you manage, is it covered under the CARES Act or is it not covered under the CARES Act? And this is really important because so many properties are covered under the CARES Act and you don't know it. So what you're going to do right now is you're going to find out, and don't waste any time. I started talking about this on March 27th. It's already, whatever the heck it is today. What is it today? It's May. We're into May deep, okay? So here we are, and potentially you could be filing an eviction on May 8th, or giving a notice on May 18th, but you don't even know if your property's covered or not. You need to find out if the property you manage is covered. Now, what does it mean to not to be covered? If the property's paid off, if a property's paid off, there's no mortgage on it, and it's not Section 8 or anything like that, it is not a covered property. You're cool. That's good. So what you need to do is find out, go through your portfolio and go through and find out, is the property paid off? That takes some work, right? You gotta have to contact your owner. And I have a form for this that you could send to your owner. And then I also have a link I'm gonna give you that's gonna be a title search company where for 50 bucks, if you want, call them up and use whatever title company you want, but this one I know will do it for 50 bucks. They will confirm that the property has no mortgage. If a property has no mortgage, then it is not covered under CARES. It's not gonna be covered unless it's Section 8 voucher or something, but you already know that. So what you need to do is you need to find out right now, is the property paid off? If it's paid off, you're going to take them and put them in this section over here. These are the properties that are not covered. These are the properties that are not that I don't have to worry about the federal law. Then if you find out there's a mortgage on the property, you're going to have to dig a little bit deeper. You might find out that it's Fannie Mae, Freddie Mac. You may find out that it's connected to the federal government. And if that's the case, then you're going to put those properties in a pile over here. So you've got your non-covered over here and your covered over here. Your covered it's going to be really important. First of all, eliminate the easy ones. Find out, contact all your owners. Now, you don't have to do this right now, but if you wait because maybe your tenants are paying. Maybe your tenants are paying the rent. So if you do it, you might just unduly scare your owner, but if the tenant stops paying rent, you're going to have to do it. So I don't know what to tell you. I don't know whether you should go ahead and try to find this out right now, or you should wait, because this could take a little while to find this out. Now, it won't take a while to find out if it's paid off. That'll be quick, but it will take a while to research the mortgage. think about that. How the heck are you going to research the mortgage? The owner's going to have to call up their bank and try getting through to the bank. I got a friend of mine who works for SunTrust, which is where we got it. We got our PPP loan second time around. And she told me, she goes, every single employee in the bank practically is working 24 hours. They are working 24 hours a day. The bank has different shifts, but it's going to be tough. So if you're going to try to find out about if the owner's going to try to find out about their mortgage to see whether it's covered or not under CARES, it's time to start doing that now. If you wait till your tenant doesn't pay the rent, then you may be pushed back even further, delayed even further. I mean, why do you want to be delayed? Now, some of you might be saying to me, you might be saying, well, Harry, I heard that you could file an eviction. I've actually heard people filing evictions right now. Can you file evictions right now? I just told you that filing evictions for non-payment of rent was illegal right now. Are people still filing them? Absolutely. They are still filing evictions right now. It's totally illegal. And it looks like the governor might have an order to have every one of those evictions that have been filed bounced out of court. So this is important stuff. Some of you are like, well, I've heard you say this. You're like, I don't care if it's covered or not. I'm just going to go file the eviction. And if the tenant wants to bring it up as a defense, let him bring it up. That's a bad attitude to have. That's a bad attitude. That's like saying, I'm going to do something illegal just because I think that maybe I'm not going to get caught. Well, if you get caught, the penalties could be pretty serious, right? So what you're going to do right now is you're going to find out cash properties, put them over here. These are non-covered properties. They're cool. They're paid off. Or maybe the mortgage is not connected to the federal government. Maybe the person's got a private mortgage with somebody. Don't have to worry about that. It's all about these over here. These mortgages where it's connected to the federal government. And that's pretty darn, there's quite a few of them, and it's bad news what you're going to get next. So here we go. You find out you got non-covered properties. Cool. You find out over here you got covered properties. Now what? Now what? If your property is covered, and hang on to your seats on this one because you're not going to like this. If your property is a covered property, then you cannot even give the tenant a notice. You can't give them a 3-day notice. You have to give a 30-day notice, but you can't even give a notice to the tenant until after July 26th. So that means they potentially could sit there all of May, all of June, all of July, and all of August. Because on July 26th is when you are allowed. That's the 120. Remember the 120 days you heard about? There's a 120-day hold, right? On July 26th is when you can give a notice. But you can't give the tenant a 3-day notice like normal. The CARES Act says if it's on a covered property, you have to give them a 30-day notice. Now, if anybody's doing the calculation, what's the soonest you could file an eviction on somebody if they're on a covered property? If they're over here in this covered pile, what's the soonest date? August 26th. August 26th will be the absolute soonest date you could file an eviction. So as you can see, if it's covered under CARES, it's bad. So what you want to do is just find out right now, am I covered under CARES? Because it's really bad. At least I'm going to find out the ones that are not covered. And you want to hear some good news? A lot of properties in Florida, as you know, are paid off. My property, I don't have any mortgages. All my rental properties are paid off. So I don't have any covered properties. So that's great. So if you were one of my property managers, you don't have to worry about a thing. If the tenant doesn't pay the rent, as soon as the governor's moratorium is over, whether it be the 17th or whether it's going to be later, a little bit later than that, you could do everything like you normally do. So there you go. So listen real carefully. If you're managing a covered property, no eviction until August 25th. That's weird. And they're trying to extend it even more. There's a lot of forces at play that are trying to make it worse. Now that's federal. There's nothing I can do about that. There's not much you can do about that. Our hands are tied on non-payment of rent cases on covered properties until after August 25th. Do not give any notices to anyone on a covered property. Do not give any 3-day notices. Do not give any 3-day notices and do not charge any late fees whatsoever on anybody who's on a covered property. Late fees are going to cause you problems right now anyway, but if it's on a covered property, don't dare don't dare give a notice. First of all, you can't give a 3-day notice. You can't even give a 30-day notice until July 26th. And if you do give a notice, you can't put late charges on there. The law is very clear about that. It says no late fees. No late fees. No other charges. A lot of you have these penalties, charges. We don't even know if a bad check charge can be a bad check charge letter can be given to a tenant if they're on a covered property. That's how messed up the law is. And a lot of you are asking me the same questions over and over again, and I have it on the frequently asked questions section of my website, but there's a lot of questions I'm like, I don't know. We don't know. The federal law blew out this crazy law. I don't know who the heck wrote this, and then now we're stuck with it. So we need to wait for Congress. And Congress has groups within Congress that in the offices there where they take laws and they explain them and they give better explanations about what things really, really are. So you could see that this is a huge mess if you're on a covered property. All right, real quick stuff. Some of you in the past, when a tenant skips on you or whatever, they owe you a bunch of money, you report it to a credit bureau. Don't report anything to any credit bureaus right now. No negative credit reporting whatsoever. Now, that's a recommendation because it's probably going to become law. Don't report anything at all to credit bureaus. Repairs. Don't report anything to credit bureaus now. After this stuff is all over and we find out what the law really is and whether we can or not, that's a different story. But for now, no late fees, no credit reporting. No, don't be doing anything like that because you're gonna get yourself in trouble. All right, repairs. What about repairs? Essential repairs? You still have to make essential repairs. If they deny you access, call the police. Call the police, call the sheriff's department, go over there, call the police and say, look, I got a flood in here, I got mold growing on, I got to get in here. Bring the police over and see what you can do about getting in. Don't try to do it by yourself. And people are denying access right now all day long. Every single day, I get probably 10 emails. And here's the email. I'm trying to show the property. The property's for sale. I'm trying to show the property, and they won't let me show it. What do you think my answer is? I'm like, there's nothing you can do. What the heck are you going to do? What the heck are you going to do? Think about it. They won't let you show the property. They won't let you in. Some of you probably wouldn't let people in. What do you think a judge would do? Who's going to be on your side? Now, in normal situations, what you would do, you'd serve a 7-day notice for failure to allow access, and you'd be able to proceed and do all kinds of stuff like that. But what judge is going to evict somebody right now because they refused you access to show, or they refused another salesperson, realtor, whoever, they refused access for showing? It's not going to get you anywhere. So know what you got to do with it right now? You got to put up with it. Now, it doesn't mean don't give a notice, but as far as filing an eviction for it, forget it. Forget it. A lot of people are refusing to allow people to come in, and some of them are being legitimate about it. Some of them are just being jerks. Let's face it, some people can be real jerks. They don't want that house to be sold. You know how it is when you try to sell a house that's occupied. They do everything in their power to not want to cooperate with showings, or they'll badmouth the property in front of people. You know how it works. Well, now it's worse. It's far worse. If you have an essential repair, you're going to have some help. If it's a non-essential repair, just let it slide, but then don't forget about it. I don't want you to forget about a non-essential repair and then have it linger, and then 3 months from now, when things may be normalized and I go to file an eviction, then all of a sudden the tenant files an answer with the court saying that you failed to repair X, Y, and Z. Then I'm going to ask you, right? I'm going to say, Mary, did you not repair these things? And then Mary's going to say, we tried 3 months ago, but they wouldn't let us in. So then I'm going to say, well, what kind of proof do you have of that? Well, they wouldn't let us in. And, I have my notes here. So now we end up in court, right? The tenant there sitting in front of the judge, all nice and looking good. And, sometimes they even bring like a child with them to make it look like they have a child. They have the fake child. And there they are. And they're like, Judge, we would have paid our rent, but the property manager failed to make these repairs. Here's my list of repairs. And then here you are, the property manager. You're like, but Judge, we tried to make these repairs and they wouldn't let us in. How are you going to prove it? How are you going to prove it? This is where you need to use what's called a confirmatory letter. If somebody doesn't let you in, if somebody says, I need something done, it's not essential. They need something done and they're refusing to let you in. You send what's called a confirmatory communication. whether it be by text, email, whatever way you normally communicate. I don't care. Everybody does things differently. This is how it goes. Dear Mr. And I have the form. I have this for you. It's as a sample, and just do whatever you want with it. It says, Dear Mr. Tenant, on such and such a date, you requested that we repair or replace X, Y, and Z. We went to do it, or you indicated that you do not want to grant us access at this time. If this is not correct, please notify us in writing. If you do want us to make this repair, please notify us in writing. Do you see what you're doing here? You're putting the ball in their court. Okay, you don't want them to come back, and believe me, I've seen it a million times. With forget the COVID stuff. I see this all the time. The tenant will refuse access or give you trouble about access, and the property manager will throw up their hands and say, oh, well, if they don't want us to fix it, then they're not going to get it fixed. And then it comes back to haunt you later. So we got to watch out for that. If they play that game, people play games. Don't feel sorry for people. I'm telling you, don't feel sorry for people. It'll come back to bite you in the butt. If they don't want you to come in, you'll respect that decision, but you're going to follow it up with a letter, communication, whatever, like I said, whatever way you communicate, you're going to let them know. We tried, you said no. The ball's in your court to let us know when we could come and take care of it. You got it? I hope you understand how that works, because it's very important. Communication with tenants. Right now, if you have a tenant that hasn't been paying the rent, I recommend that you communicate with them. Now, I don't recommend that you write some nice letter to all your tenants, which some apartment communities have done. Apartment communities are a little bit different. You know, it's a little bit different how it operates. Some apartment communities wrote out letters and it sent it out to all their tenants saying, oh, you know, we're so sorry. The situation is so bad, blah, blah, blah. Please come into our office to discuss payment arrangements or payment plans. No. I do not recommend that you do that. I don't recommend that you initiate stuff like that, because people will just do what? They'll take advantage of you. What is it in this business? When you give people something, what do they want? More, right? You all know, everybody was thinking more. And we have to be careful about it. And even in tragic situations like we're dealing with right now, crazy stuff, you got to be careful. You got to be strong, because people will walk all over you. Look, only 30% of people got their unemployment. That's a hard number to comprehend. 30%. I'm not joking. I just read it today to confirm it. 30-something% did not, only 30-something% got unemployment. That means you got 60-something% of people out there are not getting unemployment. So we got situations going on out there. And then the money from the federal government, we got that, we got the stimulus, blah, blah, blah. A lot of people are going back to work, but there are some people who are pretty much toast right now. If somebody doesn't pay the rent, yeah, contact them. But just be careful how you work it out. Maybe they'll want to do a payment arrangement with you. And I have a very strong view on this. If they're going to do a payment arrangement with you, I really feel that you should get permission from the owner of the property. Don't just go off doing payment arrangements without the owner's permission. I'm really against that. I totally am against it. Some people disagree with me on this, but I have seen property managers use their own judgment and hold off on filing evictions or do payment arrangements for security deposits. I've seen property managers do this and get burned so bad. And then the owner comes back on the property manager and says, why did you do this? I never gave you permission to hold off on that eviction because we were waiting for the tax return check. Do you want to be in that position? You want to have an angry owner? They're already going to be angry. So watch out. Any payment plans that you make, if you're going to do it, it's a business decision that you have to make along with your owner, in my opinion. If you want to just go ahead and do whatever the heck you want to do, if your property management agreement gives you that much power, then go for it. But I don't recommend it. You know, I love having power in a property management agreement. Power is good to have. But sometimes, before you exercise that power, it's not a bad idea to cover your butt and check with the owner. It really isn't a bad idea, because even though it says that you can do it gives you tons of power, even though it says it, if you do it and the owner gets mad at you, something could get bad. I deal with that with security deposits. So you ever have an owner who says, I want you to charge for this, this, and this. And you're like, they don't owe that. That's ordinary wear and tear. And now you do it. And so the owner says, no, I want you to charge for it. And you look at your property management agreement, and the property management agreement says that you make the sole decision. You don't have to listen to the owner. It's dangerous, isn't it? because if you don't listen to the owner and then you do what you feel like you're going to do, you put yourself at risk. And you have enough risk. You have enough risk. Cash for keys. Can you do cash for keys? Absolutely, as long as the owner agrees. We have the forum for that. There's a way to do it, right. Watch the video on it. It can be done. Sometimes situations are rough. An owner wants to get a tenant out. They're trying to sell the property. The tenant doesn't want to leave. And sometimes cash for keys is the best thing you can do. I just did it last year with one of my tenants. Me, right? Harry Heist, the eviction guy. And here, I gave my tenants a free month rent, and I gave them their security deposit back just to get the heck out of one of my rentals. Bizarre, huh? I couldn't believe I was doing it. Myself, I still couldn't believe. I'm like, wow, I can't believe I did that. But you know why I did it? Because I knew it would be faster to get them out that way, because they already had an attorney in the wings. It was a horrible situation. They had an attorney in the wings, and I'm like, this is the way to do it. So instead of, and I would have hired an attorney because I'm not going to represent myself. Instead of hiring an attorney and paying the money and waiting the time and having the game and playing the game, I'm like, here, free month of rent, security deposit back as long as you leave it okay. She left it spotless. She left. Everything was great. I was happy as could be. I really was. And I wasn't thrilled that I had to do it, but hey, I got what I wanted. I wanted her butt out of there, and I got her out. That's the way I did it. So that works. So cash for keys is a possibility. There's another possibility. You got a tenant who's in a tough situation, and they owe rent, right? And you're holding a last month's rent, or you're holding a security deposit. Can you use that? Can you just tap into, and I get this question a lot. It's scary that I get this question because you really should know the answer to this. Can you just tap into that deposit? Can you tap into that last month's rent? No, you can't. Unless what? Unless everybody agrees. If everybody agrees, you can. And it's amazing how many property managers don't realize that. Because you have it drilled into your head. What do you have it drilled into your head? You always drill it into the tenant's head too. The security deposit is not to be used for rent, right? We always say that. That's what the lease says. But it doesn't mean that you can't agree. So there's some situations where you have a last month's rent, you got a security deposit, and the tenant's going to sign an agreement to vacate, and the owner wants the money, wants the tenant out, the tenant wants the money. Do it. As long as everybody's in agreement, what the heck? Do it. I got the form. Use my form. It works great. It works great. It's very, very rare that it doesn't work out. There is a risk, though. You could use the security deposit for that month. You could use the last month's rent for this month that they owe right now, and then they might not leave. There's a risk. But you know something? It's rare. And I'm a firm believer, if something's really rare, I don't believe in operating under the exceptions. I like to operate under the rules. Look, if you're not going to take risks in life, you're never going to get anywhere. Sometimes you got to take a risk. But if you take a risk on behalf of somebody else, with somebody else's property, with somebody else's money, make sure you cover your own butt, because that's a risk that you want them to take. So if they agree to it, then you're all set. And I've got the forms for that. It's the agreement. And we've used these forms before all this stuff. This is not new. We've applied security deposits of last month's rent to current rent. Oh, you got a tenant who's skipping, or maybe they had some serious mold problem or something happened, and everybody's in agreement. Everybody's happy. Use the form, everybody's happy. Tenant usually does what they're supposed to do, and you move on from there. You got it? So it's pretty simple. You have options. You have options. The main thing is keep the lines of communication open. Use the right forms. Don't show all your cards. Don't show any signs of weakness. Understand what the tenant's dealing with. Understand what your owners are dealing with. Just kind of take like a big approach, like a nice full approach on everything, and just say, things are different right now. This is not normal. This is not normal. Some of you are doing really good right now. You've actually used this time to build your business. I know. I'll tell you, I got a lot done even though I've been super busy with with dealing with it. The emails are killing me. But I also, for the first time, I looked at my numbers. I looked at things in our office that we were doing. I got projects that I wanted to get done. I've got staff, because evictions just dropped off like a rock. I mean, boom, like that. So I've got all these people that usually do the eviction. I got them doing other things, getting things done. Use this time wisely. Learn about things. Some of you are learning about how to do self-showings, things that maybe you didn't do in the past that now you're like, you know something, maybe this is a good idea. Maybe this is something that we need to consider. You're learning, you're taking advantage of things. You're getting on these webinars. You're joining the Facebook groups. You know, there's a couple good Facebook groups out there, the Property Management Mastermind group. There's another one for brokers and owners. There's a lot of knowledge out there. Yeah, there's some misinformation, but man, if you want to be surrounded by a lot of people, you need to be in these groups. These Facebook groups are excellent, and they also will show you dumb things that people do too, and you can learn from other people's mistakes, and that's really good. All right, where are you going to get your information from this point on? Well, there's some news could come out any day now. And most likely, the Narpm chapter will send you information. Most likely, FAR will be sending out information. The Florida Apartment Association is going to be sending information. I'm going to be sending information, but the first thing we're going to do, we post it on the website. That's the very first thing we do. Evict.com is where we dump everything. And I'm not done with Evict. You notice Evict.com is a new design. I'm not even nearly started on it. I haven't done anything to it since the new design. I've got hundreds of articles that we're dumping on there, but I want to put them on so that you could find them easily in search and all that stuff. But it's a great resource for you. Your main person right now is going to be your lawyer when you've got a situation. When you've got a situation you don't know what to do, you're going to stop. Just put on the brakes, stop sign. I don't know what to do. Just like when a tenant dies or if a tenant gets shot on the property or there's a big fire on the property, what do? I don't know. You stop. Don't make any stupid mistakes. Don't do anything hasty. Get the information you need. There's no charge to email us. Most of the landlord-tenant attorneys, they don't charge you to email them and get answers or call them. Get the answers. Don't just whatever you do. You're ready to serve a notice. You're ready to serve a non-renewal. You're ready to do this. You're ready to do that. Just stop. Don't do it. Just wait. Get it. Get the answer. That's what we're all about. That's what being in Narpm's about. That's what being in a group is about. You get contact with people like me, and I'm not the only one in the world in Florida that does this stuff, but you're going to get the information you need. You guys who know me really well, you know what gets me really angry. If you come to me after you mess something up, I'm probably going to tell you that I can't help you. I'm probably going to say, this is too messed up for me to help you. Just like if somebody comes to you with a property they want you to manage and it's really messed up and you're like, I don't want to take on this, right? You turn down accounts, right? I turn down cases too. And oftentimes I got to turn down cases, sometimes with current clients who I really love and I want to help, but they got themselves in a mess so bad. You know, that 3-month-old festering mold case? Excuse me, why didn't you call me up 3 months ago and tell me about the mold so I could have, it's all, this business, learn something in this business and apply it to everything that you do. Early intervention, early intervention. Don't wait, don't do anything quickly. Don't wait until things get messed up or don't try to figure things out on your own. If you've got free resources, use the free resources you have. You could post it on the Facebook group. You could email me. You could talk to other people that you know that are in Narpm or in the Property Management Council at Aura or whatever property management council or committee that you might be in. But ask people. Just be careful because you can't always trust that another property manager has the right answer. You can get ideas, but you can't always trust the answer that you get. So you want to just be careful what you do. Don't go into anything too fast. Look, we've been through a mess before. You guys, who survived the best? What is one of the businesses that survived the best during the 2008, 2006? What business survived during the crash pretty well? Property management, didn't it? And you're going to survive through this. It's going to be hard. Going to be some problems, but the last thing you want is to have some lawyer sue you because of something that you did because you didn't check or you didn't do the right thing. The last thing you want is to have to shell out $5 grand on something that's going to eat into your profits and ruin your life. So do yourself a huge favor. When you're not sure of something, get the information that you need. Now, some of you say, I'm getting so much information, I can't get through all this stuff. I'm getting emails from Narpm, emails from FAR. I'm getting emails everywhere, email. And if you notice, we didn't get on that bandwagon. I sent one email out right after right before March 27th. I'm not pounding you guys with emails. I just don't want to do it. I don't like it. It's not my style. You know where I am. You can come to me and I'll be happy to help you and give you the forms, give you the notices. And after the class, Alex and Laura, one or both, are going to send you all the things that we talked about today, and there's some neat stuff that you're going to read, and all the forms, all the notices. But the thing is, you could have all the tools in the world. And I've said this before. These are tools. Forms and notices are tools. And you could have all the tools in the world. You can go out to a store and buy every tool that you could imagine. Do you know how to use those tools? That's why it's important. You take a tool before you use it. You know, you can do a lot of damage with a tool. You know, imagine taking a router or a bandsaw or a skill saw and not knowing what you're doing. I've made some mistakes with tools. You don't want to be making mistakes with your notices. So just take your time. Right now, we pretty much covered a large amount of material. If you guys have any questions, shoot. Let's go. Let's do them. If you have a question that you don't want to ask in front of everybody, I don't mind. Just email it to me, and I'll try to help you. But do you know if we have any questions?
Yes, we do. All right. The first question is, regardless of current legislation, whether Florida or federal, if the tenant fails to pay rent owed, do they still owe unpaid amount in the future?
You mean, is the rent forgiven?
Yes, correct.
That's a great question. And you know, I really should make that clear, because it's not forgiven. There is no rent forgiveness whatsoever. Now, will there be late charge forgiveness? Will they say that because if it's under care, clearly you can't charge late charges. Will there be forgiveness of all that? Yeah, probably. But as far as rent, there's no forgiveness. But a lot of tenants think that. I don't know if you saw that thing that was circulating the internet. There was that picture of that screen, and it was like, and tenants are looking at it. They're like, oh, cool, we don't have to pay rent anymore. Our rent's being forgiven. There's no forgiveness yet.
What about tenants who break their lease due to the virus? Are we still able to claim on their deposit due to non-payment of rent?
Awesome question. We don't know. We don't know. If you break you got a contract. This is a contract. There's nothing in Florida law, there's nothing in the CARES Act that says that if you lose your job, if you get sick, if you have a job transfer. You ever people say that? Well, I lost my job. I have a job transfer. I bought a house. I could break my lease. We hear that all the time. There's nothing in the current law that allows that.
Okay. Are holdover tenants still allowed to be charged 2 times the monthly rent?
Yes.
Okay. Can a condo
but now
associate...
think about that. If they, how do you charge them? Remember, if they're a CARES property, if they're a covered property, you can't give them any notices for it. You can give them a reminder letter. The reminder letter tells them what they owe, but you're not going to be able to. I've never been a proponent of the 2 times rent. If somebody's a holdover tenant, I recommend that you evict them. But in a situation like we're in now, where you can't evict them potentially, then sure, double the rent.
Okay. You discussed rent reminder notices. How do these have to be delivered? Email, door, or by mail?
Okay. When we wrote it up, originally we had the normal, we took a 3-day notice, stripped it down, took everything out that was dangerous, and we had it where it could be hand delivered, posted on the premises, and then all of a sudden people started contacting me. They're like, Harry, my tenants don't want me to go over to the property. They've told us, don't dare put a notice on my door. So that's where you're going to do it by whatever other means. And I'm hoping professional property managers, old-fashioned, old-school property managers communicate with their tenants by mail. Progressive, on top of everything, property managers, they're using texting, using companies like Property Text Box or within their software programs. Those texting programs, I absolutely love them. I'm not talking about getting text from your tenants or your owners. No, I'm talking about the programs where you text out through the computer and the text comes in through your computer, or email, whatever. But some people, they don't even want you to dare come to their property and put a notice on their door.
All right. Can a condo association tell you aren't allowed to show during this time?
They can do whatever they want, right? Condo associations? Yeah, and they do. They do whatever they want. Yeah, they can. Do they have any legal authority to do it? Probably not. They do a lot of stuff without legal authority, and no one challenges condo associations, which really stinks. And that's why things have gotten so out of control. They're worse than ever before. So I don't know what to tell you.
You stated previously that there is a title company that can do the search for the covered and non-covered properties. First question is, do you know the company that will do that? And two, what documentation can we request for confirmation that it either is or is not covered?
Okay. Well, the title company, I don't know anything about this. It was recommended to me by somebody else. I don't know the guy. I sent him I forget how I even found him. I sent him an email. They said, what does it cost to just find out? And that's going to come in that Dropbox link. I put him in there. I can't vouch for the guy. I have no idea if I don't even know if he's legit, but I heard good things. This is a title search guy. There's title search companies out there, not just title companies, but you might have a friend that does title work. You could ask them to do it, but I'm going to give that to you. The second question was,
what kind of documentation? Yes.
Yeah. Well, right now in Michigan and in Georgia, in order to file an eviction, you have to sign this little affidavit. And we might be doing that in Florida. And if we do, that'll actually be good. It's an affidavit that the owner is going to sign, stating that to the best of their knowledge and belief, it's not a covered property. The mortgage is not covered property. But we don't even know what kind of documentation to get. I would just tell your owners, if necessary. Remember, you don't have to do it for everybody. If people are paying the rent, you don't have to worry about it. But if you do have to do it, you're going to tell your owner, Mr. Owner, we can't file an eviction unless you have to contact your bank and you have to ask them, is this connected to Fannie Mae, Freddie Mac? And most banks should be able to tell you that. And if your owner doesn't do that, guess what? The eviction doesn't get filed.
How can a judge enforce the reason for non-renewal? For example, if the reason is the owner is going to sell the property, how can the judge know that happens months later?
Okay, I'm not really sure what you mean. If you, let's say I file an eviction right now for non-renewal, and the tenant comes into court and says, you're non-renewing me because I haven't paid my rent. And then you're going to say, no, we're non-renewing you because the property is going to be going for sale. And then we produce the evidence that that's why we non-renew them. So I don't think that's a big problem. I think we'd be pretty successful in that. What I don't want is for you to be grabbing at straws. You're like grabbing. You're like, I'm going to evict them for the unauthorized occupant or the grass or this or that. In this environment that we're in right now, forget it. Judges are not going to want to evict people unless it's something serious.
And just remember, this is not me asking the questions. I'm just a moderator in this.
That's right.
My owner wants to sell his property. They were given notice in the middle of February prior to CARES Act to vacate at the end of March. They are currently mostly on rent, always a little late. They have not moved yet. Can I file a notice for eviction?
And it's not a CARES property? Yeah, I don't see any problem with that at all. If the courts are open. I mean, you got some courts that are just plain not open, but a lot of courts are, absolutely. Evictions are still being filed legally. There's some were being filed illegally, the ones that were for non-payment of rent, the clerks were taking them, but no, remember, it's all about non-payment of rent. That's what the purpose of the law is to keep people in for non-payment of rent. Now, is any judge going to be thrilled with evicting people? No, but non-renewals, look, I mean, come on, you got to sell a house or you've got somebody that's month to month, we could do it.
Okay, if a tenant states they have COVID-19, whether they do or don't, and that's why they were staying home not paying rent, who pays for the cleaning of the property? Will we have an addendum of sorts that can help in between properties?
I have absolutely no idea. I know for a fact that a lot of the restoration companies, and there are a lot of them are members of the association as well. The restoration companies are doing sanitization, disinfecting of these places. I don't know if that's legit. I don't know if it's unnecessary. I have no idea. There's other people who say that as long as you leave a place empty for X amount of days, anything, whatever germs or virus is going to be gone. I have no idea. But the question is, could you charge the tenant for it? I doubt it. I doubt it. Now, when somebody dies, if somebody dies and their bodily fluids get all over or they shoot themselves, yeah, you could charge for stuff like that. But for this, I doubt it. I don't know, though.
How does the CARES Act affect COA assessments?
It doesn't affect it in any way, shape, or form. A COA assessment goes to the is to the owner of the property, so it doesn't affect that. You know, I didn't mention this, but if your owner asks for forbearance on their mortgage, it could actually throw a non-CARES property into a CARES property. But I don't want to go there. That's like really overcomplicating stuff. Let's just hope that doesn't happen.
We have a clause in our lease that says if tenants refuse showings, we can charge them $25 per refused showing. Can we still charge that?
I don't think you can. I don't think you can. First of all, it's a penalty. It's a fee. And it's if it's a CARES property, the answer is a flat out no. But you know, you could argue that, yeah, they agreed to it. It's in the lease, they agreed to it. But I could show you court cases where people agreed to something and the court found it to be totally illegal. Would that fly in court? I always ask people this question. I say, I ask them to do this scenario. Put yourself in the judge's seat there. What would a judge do? What do you think a judge would do? You think a judge is going to feel sorry for the tenant, or they're going to feel sorry for the owner? What would a judge do? And because that's what, when you don't have law either way, when you go to court, there's always a decision made, right? Maybe it might not be made that day. There will always be a decision made. If there's no law, the judge will make their own decision. And that's the danger that we have. So I don't think it would fly.
Okay. If property is owned outright by owner, if what you're saying, if the government does not extend the executive order, when can I put up the 3-day notice?
May 18th, Monday, May 18th. You're going to go up there with your 3-day notice or 8-day notice, you know, whatever notice you normally use. And you're going to, but don't put any late charges on there. Make it nice and clean. The cleaner, the better. You want your cases to cruise right through. You don't want any delays.
Can I charge late fees on a non-covered property?
I would not. The law's not clear, but I would not. Because think about it. You're charging late fees when you couldn't have even filed an eviction. So you could make an argument that it's impossible to file an eviction. The courts won't allow you to file eviction. Therefore, and think about it, when the courts are closed, if you can't even give a notice excludes court observed holidays. So if the courts are closed, you could just make up all kinds of good arguments that won't fly with the judge. I know you guys love your late fees. I know it. Okay, I absolutely get it. Late fees are a big source of income, but do you want to have that short term? Look, you're not going to collect them anyway. Okay, so think about that. Do you want them to screw up an eviction for you, or do you want your eviction to go through it and get rid of the tenant? That's the way I look at it.
Why can't you put late fees on rent reminders?
Because on the CARES properties, it says no late fees whatsoever. CARES is real strict about that. Take a look at it and go to our website. You can actually read the it's not a long section. It's just like half of a page, and you could read it. And it's real easy. So just go to the website and press the button. It's kind of fun. If you haven't gone to the website, go there, because you're going to get a lot of information in one shot.
You mentioned NSF fees earlier. Are you advising against charging an NSF fee for a rejected return payment during the COVID-19 issue?
We don't know. I recommend that you charge them. Okay, when I say charge them in the software, on the books, charge them. Just do not try to collect them now. Nobody, all this stuff, late fees, NSF fees, all that stuff, unless it's a CARES property. If a CARES property, it's a different story. Go ahead and charge them on the software, on the books. just don't try to collect. It's the act of trying to charge. When I say, and I try to figure out how to say this without being confusing. They owe it, but you don't want to charge it to them where you actually tell them, hey, you owe this. And when you think about it, it's absurd that somebody bounces a check, they should pay that money. But it is a fee, it is a penalty, and the law says no fees or penalties right now. So what the heck does that mean? So I say charge it, and then as we get to see, right now we don't have all the answers. We're hoping that as time goes on and Congress comes out and the courts are going to start coming out and give us direction, because we're not the only ones. Think about it. The whole United States is covered under CARES. So we're not all alone here in Florida. We got the whole country. And then as time goes on and we're connected to all these different lawyers, and there's all different lawyers in Narpm and the associations all throughout the United States, we're keeping in touch with each other and trying to get real advice. Right now, we just don't know. But whatever you do, don't be giving your tenant a notice that's a bad check notice right now, because because somebody like that, wait till they watch something on TV or read an article and they're like, oh, my owner gave me a notice, and they go run into legal aid or some slimy attorney who's taking these cases and representing tenants, and next thing you know it, you got a lawsuit on your hands. And win, lose, or draw. If you get sued, you're going to have to pay. You don't want that.
What is your thoughts on rent increases during this time?
There's no law that says that you can't do it. Now, if it's not a CARES property, do whatever you want. There's nothing in the law that says that you can't increase rent.
We have an owner who currently has a Fannie Mae property and tenant is not paying rent. The owner wants to pay off his mortgage so we can follow through with an eviction when allowed. Will this work, or would the fact that the owner previously had a government-involved loan prevent this?
That's a really good question. I don't know. I don't know, but it's not the first time I got that one either. Because a lot of people are close to paying off their loans, and they're like, hey, all right, I owe $15,000. Here, I'll pay my $15,000. I don't know. I think I can make a good argument that the property isn't covered, because now at the time of the default, at the time of the tenant's default, it was probably covered, but now it's not covered. Now, what about, how about the rent going forward? Like if it's paid off today and then they owe June's rent, well, clearly June's rent is not covered, but what about May's rent if it wasn't paid off until mid-May? I don't know. Those are stumper questions. Those are good questions.
What happens if we've already posted a 3-day notice with a late fee charge? What can we do?
What happens if you did it already?
They've already posted a 3-day notice with the late fees charge. The property is clear and free, not under CARES Act.
Okay, it's not going to be valid at all, so don't worry about it. Just post a new 3-day notice on May 18th if the governor doesn't extend. Don't worry about it. Don't be filing any evictions after May 18th, if that is truly the date, and we don't know if it's going to be, but May 18th or whatever, on that date, you're going to give nice, clean, new 3-day notices, wait your 3 business days, not including Saturdays, Sundays, or legal holidays, and then bang, we're going to file the eviction.
If the date is extended past 5/17, will you post that on your website?
Oh, man. The moment I find out, it's going to be all over Facebook, it's going to be on my website, and I'm going to shoot a video. You should know me by now.
Yeah. Our lease has a $100 discount if rent is paid on or before the 5th of the month. Technically, it is a built-in late fee, but it states it as rent. How would that be looked at as far as whether we can collect it or not?
I have no idea. It's not really a late fee. It's a prepayment discount, right?
Mm-hmm.
So, but the judges over the years there have been judges who said that's just a disguised late fee. But I don't know. I think it's a prepayment discount. I think you'd probably get away with it.
It was under my understanding that under the CARES Act, you could not serve non-renewal notices for any reason under covered properties. But Harry mentioned that you can non-renew any lease. True or false?
Yeah, you still can, but you have to give a 30-day notice. 30, no matter what, it has to be at least 30. Like for instance, let's say it's a CARES property and it's month to month, and you want to non-renew the month to month. Well, normally, how much notice you have to give to non-renew month to month? At least 15 days notice, but now everything becomes 30. So you can non-renew. And I got an article. I have an article on non-renewals and an article on non-compliances. So in fact, Dave wrote both of them. I shouldn't say they're my articles. Dave wrote, I started and then Dave finished them up. But that'll give you a better understanding. Read those articles on non-renewals and non-compliances.
Last question, because we are running out of time. Owner wants to sell his house during this time with the lease ending September 30th. Is that advisable?
Okay, the lease is ending September 30th?
Yeah.
And he wants to sell it right now. Okay, well, he's going to have to put up with the normal baloney that tenants put you through, the hell that they put you through when you try to show the property. But you know, and that's a whole other issue. I got a video that I did on that exact thing about when, if you have a property that you're managing and it's for sale, what do you need to do to get cooperation? And that's, so, you know, anytime you put a property for sale that's occupied, you're asking for trouble. You know, is the tenant violating the lease? Yes, but you're just asking for trouble. But hey, you know, some tenants are cool about it. Some tenants, if you throw them a gift card for something, or if they're nice, cool people, you know, it's always the bad apples. But the majority of people aren't bad.
All right. Well, thank you, Harry, for all this great information. Like I said, we are recording this, and this will be being posted later, and we will be sure to send out all the information Harry was talking about that he will provide to us. I'm going to pass it over to Laura, who can close this out and tell you about some of the upcoming things and some discounts we have on membership.
Thank you so much again, Harry. Great information.
Thank you. Thanks for
We
having me.
really, really appreciate you doing this for our chapter. Thank you so much.
Thank
And thank you, everyone, for joining us today. You've taken the time to invest in yourself and in your business and your profession today, and I commend you for that. For signing up for membership, I just posted again in the chat that you can contact our membership chair, Christy Lake, C-Lake at watsonrealtycorp.com. Everyone, have a great day and take care. We're all in this together, so hang in there.
Thank you.
Bye,
Thanks again.
everyone.
Bye.
Bye.